Yo, 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 yo. What's poppin', everybody? Welcome to Straight Talk TV. Thank y'all for tuning in. If you haven't already, do me a big solid. Hit that subscribe button for me, y'all. Tap that little bell notification icon so you get notified with the latest content, updates, and information from me, Straight Talk TV. Yeah. Hit that join button also. Become a channel member. Rock it out with the Straight Mob. Y'all know how we do this. Let's jump right into this. Yo, hit that like button for me. We got YNW Melly, and he was back in court today, and y'all, it is a lot of shocking revelations coming out about this upcoming trial, or possibly could there even be a trial? Like, could this be one of those situations where this doesn't make it back to trial? Because a lot of stuff is starting to come out. We're gonna take a look at some of the hearing this morning, and we're gonna talk about, what's going on with this trial, because it's looking like that it might not even be a trial, possibly. But we'll see how that goes. Real. We'll see how that goes. Hold up one second, y'all. I had to come grab something. And then we're gonna get into this footage from this morning. So let's check out this morning.
Or you guys are time. If there's any confusion, whatever, we understand it's for this week. That's not an issue.
So, the judge, the state's argument, well, at least in because of a few things that the defense has said, they seem to want to indicate that the state is minimalizing the issue. We have been very transparent. Two ASAs have already testified. Boutros and Ms. Wagner. Ms. Wagner was even under subpoena and she testified. So to say that the state is either hiding something or trying to minimize something, how can that be when they have put on the stand for this court to hear their star witness in a $1 million ASA? So doesn't make logical sense that you've already put on those witnesses and there's been no evidence whatsoever that there was anything along the lines of a cover-up or an institutional breakdown from the state attorney's office. To the opposite, the court even commented last week that upon reading the deposition of Ms. Boutros and listening to the testimony of the court, there was no indication that the state attorney's office prevented anybody from saying what. So they have what they need. And there was nothing from either one of those witnesses that would indicate any further investigation needs to be done. But turning back to the issue today is the motion to quash and protect.
So basically, he's saying that the prosecutor and them, like, they are trying to basically manufacture evidence. They're trying to make evidence or go down avenues of investigation that they shouldn't even been investigated.
For the subpoenas this week. The state cites to the case of Coca-Cola, state versus Coca-Cola bottle. On page 2 of the state's memorandum of law in support of motion to quash subpoenas, then it's found at 582 7th 2nd 1. It's a fourth PCA case in 1990. wherein the court ruled there was the state brought conspiracy charges against PepsiCo for conspiring to fix prices. And the Pepsi ended the case settled, and Coca-Cola was still going. And so they issued subpoenas for the state's attorneys to appear for deposition and also for their records. And so in that case that outlined, first of all, any state agency such as the state attorney's office has to comply with the public records law of the state. The public records law of this state says that a state agency's work product, when it comes to public records, that's written records found in the file, not oral, are protected until the case closes. At that point, the state's file no longer can the state claim work product or attorney-client privilege on anything that's in that file, public record.
Yeah, public record.
Why does that happen? That happens for a reason. Because that is to allow whoever, the defendants, attorneys, whoever, can ask for all those files to be able to go through them and see whether or not they find Brady evidence or they find some other evidence to be used in 3.850 post-conviction. And if there was Brady found in that file, the work product, when they're looking through the state's actual physical file, they could then make that claim in a 3.850 motion, they could make it up to court, and the entire case could be reversed and sent back to the trial. But there's a distinction, and Coca-Cola Bottling Company makes the distinction between a written product that sits in the state's file and oral testimony. They say that the attorney-client privilege for oral testimony for the state's attorneys applies all the time. It doesn't get waived because the case is closed. So it applies when it's closed, and it applies when it's open to oral testimony. So in this case, that privilege, that attorney-client privilege, cloaks everything that happens between the agency, which is the state attorney's office, and its attorneys, the assistant state attorneys. And that's why there should be no further inquiry into the witnesses that are listed in the subpoenas this week. And that's why we ask for a protective order. For those of you who cross and for a protective order, they not be issued again, because that privilege applies. The defense wants to parse out the, well, you know, the work product privilege really doesn't, you know, and it's fact, that doesn't really apply. It does, when it comes to oral testimony. And if you add on top of that, they see the reason why the court should not watch subpoenas is because there's systemic problems, institutional problems in the state attorney's office, they're not telling the truth, they're not being forthcoming, and that goes against everything that you heard last week from the two state attorneys who did testify. So today, the court stands here with these motions quashed and for protective order, which I agree with the defense. We can't really go any further until there's a ruling on these because we're kind of stuck in the water. And the court seemed inclined last week to mainly grant these motions, but you gave the defense additional time to make more argument. And nothing has changed since last Friday. That attorney-client privilege that is cloaked over the state attorney's office, it still remains. And there should be no, it's important, it's there for a reason, and it should not be disregarded. And we let them last week go ahead with the facts. You know, they say we're not transparent. They got out the facts. ASA testified. And yet there was no indication whatsoever that the state attorney's office itself has done anything improper or wrong. If anything, it's just stolen the children. So that's why, under the attorney-client privilege, we asked the court today to grant the state's motion to quash and for protective order on the witnesses the defense has set down this project for oral testimony before this court. They are protected under that privilege, and they have not shown any reason to this court through the testimony of last week that there should be any further investigation into the state attorney's office. So therefore, for those reasons, I'm asking the court to please grant the state's motion.
Thank you, sir. Your Honor, obviously the court knows I just received this memo. I read it, and I'm going to do my best.
So the prosecutor doesn't want the defense attorneys to subpoena and re-interview the witnesses that the state has for this case, which that's kind of strange and odd. That should be telling enough right there to show people and tell people that, you know, the way this case is being prosecuted and has been prosecuted, it is something definitely off going on. It is definitely something off going on with this prosecutor office in this case right here.
Response to it. So if my argument is a little disjointed, I think the court would understand why. First of all, the state acknowledges in many of their pleadings that they waived the privilege as far as Ms. Boutros testifying at deposition and at the hearing that we had. They waived that privilege for Ms. Boutros. They waived that privilege for the subject matter. They don't have the right to pick and choose. We waive the privilege for this witness because we like what she's going to say or don't like what she's going to say, whatever their reason may be. We waive it for that witness, but we're not going to allow you to talk to these other witnesses. The privilege was waived by the state attorney's office. They've acknowledged they waived it for Ms. Boutros. The state now today argues, well, Ms. Bradley came in here and she also testified. You had to order her to come down from, we were told it was a deposition. I've learned now that she was talking to other legal authority. I don't know what the truth is. I just hear different things. But you ordered her to come down to testify. This was not the state being magnanimous and coming in and saying, please talk to Ms. Bradley. But the bottom line of it is they voluntarily waived whatever privilege they had when they authorized and allowed Ms. Boutros, A, to talk to Mr. Benjamin off the record, B, to give a deposition, and C, to testify here. That has been waived.
Man. So y'all see. Woo! That's what was going on this morning in the hearing for the Y&W Melly upcoming trial. And the way this is looking and going, we might not even get to another trial because it's a lot of bogus stuff starting to come out about this prosecutorial team. You know what I mean? It's a lot of shady stuff starting to come out about them, man. Real spill. But that's what happened this morning during the hearing they had this morning for the Y&W Melly trial. And y'all hit the comment section down below. Let me know what y'all think about this whole situation. And if you heard something, let me know about it. You know what I'm saying? Yeah, you know what I mean? Hit the comment section, man. Oh yeah, and don't forget, hit that like button. Let YouTube know you want to see more of this here content and you rocking with your boy. It really helps me in the algorithm. You know what I mean? And I appreciate you guys, man. Salute to everybody. Much love and respect to everybody out there. Everybody out there that's, you know what I'm saying, grinding and getting, keep grinding. And we'll catch you guys on the next go round. Straight Talk is out.